All right, Miss Angie, you may call the next case, please.
Sarah Bryant versus State of Tennessee.
Certainly.
May it please the court, I'm Andy Clark from the Memphis-Shelby County Bar, and I represent Sarah Bryant, who is the appellant in this matter. I would like to reserve 5 minutes for rebuttal if necessary.
All right, sir. You may proceed.
Your Honors, we're here on a trip and fall case that was brought by Ms. Sarah Bryant against the state of Tennessee, arising from a trip and fall which occurred at a classroom for which she was a student on 3/13/2017. This case proceeded through the Claims Commission, and we had a bench trial before Commissioner Hamilton, where he entered an order of dismissal, dismissing all of plaintiff's claims arising from the fall. In this particular case, because it's a bench trial, I understand there's a difficult standard for me with respect to credibility determinations. But in this particular case, what we're trying to say is that there was a particular type of activity that was going on that exposed the students to risk. And even based on Professor Lancaster's testimony, she had the opportunity to and did check, but she was just negligent in her inspection of the classroom. In this particular classroom, there were 2 sections to this lecture on the particular day that Ms. Bryant fell. The first section was lecture, where you have just students in desks, or they're kind of like tables, and the classroom is set up in a particular manner, and there's photographs in the record, exhibits 2 and 4. There's a number of photographs, but the classroom is a large rectangle. It has a podium up in front of it, and if you're at the podium to the left, there was a round table in it, and to the right there was, I don't think there was anything else. Miss Bryant fell while she was doing the thing up by the table to the left of the podium. Now this particular activity that occurred after they came back, after they had their lecture and they came back, involved 19 students going to different stickers on the wall and performing evaluations for the classroom. They had to switch every minute. There were 19 students going clockwise, 19 students going counterclockwise. So we submit that that because this activity was going all along the walls, it was very important for Professor Lancaster to check the walls for any dangerous conditions. Now, because this case is against the state of Tennessee, pursuant to the 9-8-307A1C, that allows the state to be responsible for injuries that occur on premises to the same extent as private owners of property. So there are a number of ways that you can prove liability in a trip and fall case. And one is when the state or the landowner creates the condition. I'll admit we do not have any evidence of that. We thought there may have been, but the proof just fell short of that. There was a cord that was plugged in or by the table where Miss Bryant fell and injured herself.
Let me ask you a question about that.
Yes.
Your client testified she saw a cord when she was on the floor.
Correct.
Is there any other evidence in the record of anyone seeing a cord or seeing anything else?
No.
Okay. How does that not become a credibility issue for the trial court?
Well, if you look at the court, Commissioner Hamilton's finding of fact number 14, it admits there was a cord there. Okay, so I am not understanding the proper standard. It's on page 34 of his order of dismissal, and he holds as a finding of fact, initially the claimant did not know why she had fallen. However, as she was being helped up from the floor, she realized she'd been sitting on a cord. The cord was on the floor. It was near the wall on the circular table. The cord was black in color. The carpet in the OT Smart Classroom was dark gray and black. So I have to, understanding my burden, Commissioner Hamilton wrote a 43-page opinion,
He did write a long opinion.
summarized all the evidence. I can't fault him for what he did, for what he's done, but he has found that as a fact, and that is critical, because if he had made a finding that said, I find there was no cord, that would be a straight credibility issue to where I would have a difficult time even attempting to appeal the case. Now, because there was a cord there, what we have to look at, we cannot prove actual knowledge. Okay, that's one of the standards for a slip and fall or premises case. We cannot prove that the state created the condition, so we have to prove constructive knowledge. Okay, and constructive knowledge, the best definition that I had for constructive knowledge is information. This is from Parker versus Holiday Hospital Franchising, Inc., 446 Southwest 3rd, 341 Tennessee Supreme Court, 2014. Information or knowledge of a fact imputed by law to a person, although he may not actually have it, because he could have discovered the fact by proper diligence and his situation was such as to cast upon him the duty of inquiring into it.
Let me ask you this. I agree with you that the trial judge did find that there was a cord there. But on page 40 of his order, he makes this finding. In order to establish constructive notice, claimant must prove the dangerous condition or hazard existed for such a period of time that a reasonably prudent person would have or should have discovered it. And then he goes on to say, the testimony clearly showed the cord was not on the floor or plugged into the electrical outlet just before the learning activity commenced. Professor Lancaster remained in the classroom, continued to survey the room while students were engaged in the learning exercise. However, she never saw a cord.
Right. And
So if it wasn't there, was not on the floor or plugged into the electrical outlet before the learning activity commenced, which was when she made the survey of the room and whatnot, then how could she possibly have constructive notice of a condition that existed for such a period of time when this person fell almost, within minutes of coming back after the activity?
Okay, this was a this was a 3-hour class, an hour and a half of lecture and an hour and a half of the exercise. This fall happened at the end of the exercise. And it
didn't happen to anybody else?
Correct. There were 18 or 19 people who had been through or past that. The issue that I would take issue, the way I would respond to that is, you have to look at what Professor Lancaster said she did. Okay, if you look at page 57 of the trial transcript, he said, "Did you check for hazards before the class?" And she said yes. I asked her, "Did you check the outlets?" And she said no. After she took a break, she said she scanned the pathways. This fall didn't occur in a pathway. This fall occurred behind the podium to the left of the podium, not where the classes are. So she didn't actually look at the spot where she fell. And with respect to constructive knowledge, I think you're supposed to have constructive knowledge, whether it's 1 minute or an hour or stuff. I think constructive knowledge is there so we make sure that we're not holding somebody accountable for something they couldn't have seen or didn't look for. Here she looked. She looked twice, and she didn't find it.
But this finding talks about it before this learning activity commenced.
Right, and her testimony is she only told them, that's at page 96, when she came back. On page 96, lines 9 through 20. You didn't check after the break. I wasn't checking for the outlets. I was looking at the floor space more, the pathways. So she's looking in between the students' desks, and my time is about up, Your Honors.
It is, but you can answer the question.
Excuse me?
Have you answered?
That's fine.
I believe I have.
Okay.
We are relying on her actual testimony. I think his ruling, he found there was a cord in paragraph 14, and it's around paragraph 40, page 40, it may change a little bit, and I think the actual testimony.
Well, it doesn't deny there's a cord. It's whether or not it was there for such a period of time that constructive notice would attach, I think is the question. That's the issue.
Thank you, Your Honor.
Thank you.
Thank you.
May it please the court. My name is Heather Colturi, and I represent the defendant, the state of Tennessee. As previously, as Mr. Blanked out on his name, that's embarrassing.
Mr. Clark.
Mr. Clark noted the issue on this, on appeal is whether the commissioner correctly dismissed the claim based on claimant's failure to present sufficient evidence of constructive notice. Here, the two theories of constructive notice that claimant relies upon is first the passage of what I refer to as the passage of time theory, which is whether the dangerous condition existed for such a length of time that the defendant in the exercise of reasonable care should have become aware of the condition. Or the other theory, which I call the common occurrence theory, which is whether there's evidence of a dangerous condition that occurs regularly as part of a pattern of conduct, a reoccurring incident, or a general or continuing condition. The court should affirm the commissioner's dismissal of this case based on claimant's failure to present sufficient evidence of constructive notice for 3 reasons. First, claimant failed to present sufficient evidence regarding the length of time that the laptop cord was allegedly on the floor in the area where she fell prior to her fall, which is fatal to her ability to prove constructive notice under a passage of time theory. Second, to the extent that claimant still relies on a method of operation theory to prove constructive notice, this theory was expressly rejected by the Supreme Court of Tennessee in Blair versus West Town Mall, and the commissioner correctly did not consider this theory at trial. Third, the commissioner correctly determined that the preponderance of the evidence was insufficient to establish constructive notice under a common occurrence theory. Briefly, before addressing the arguments raised by a plaintiff, I want to address some of the factual statements that he made Mr. Clark made during argument. First, during the classroom activity, there were 19 activities and 37 students. I believe he testified that there were 19 students walking around. It was really 37 students divided into 2 different groups. So at the time of claimant's fall, they had already had 18 rounds of the activity, meaning 36 students had walked past the area where claimant fell.
Excuse me for interrupting, counsel.
Yes.
As I understand from appellant's argument, students were crossing through one another. Some were going clockwise, others were going counterclockwise, all during this activity in the classroom. Is that correct?
Yes, so they were at 1 minute intervals, so they were given 1 minute to travel. There were stickies along the wall about 3 to 4 feet apart. And Professor Lancaster would announce time after 1 minute, and the students would rotate, like so, one group going clockwise, the other counterclockwise, to the next station. So they would rotate every minute, but they weren't, again, they were 3 to 4 feet apart along the perimeter of the classroom on the walls. Does that answer your question?
Yes, and it's also my understanding from the testimony in the record that the professor at the commencement of the class asked students to clear areas and not have any backpacks or books in the pathways, but that those should all be stored in the center of the room. Is that correct?
Okay, so prior to the actual, I think you said at the beginning of class, but it was, so like Mr. Clark testified, it was a 2-part class. So first part was lecture, and then they took a break. They came back from the break. She explained the activity, and then she instructed them to put up their stuff either under their desk. They were at rectangular tables, not at desks, so it was a long rectangular table along several tables along both sides of the classroom. And they were instructed to put their stuff up either under the table or on top of their desks or in their chairs.
And at what point did the professor make a survey of the room and the pathways where the students would be?
Professor
walking?
Lancaster testified when she walked into the classroom that day before class began. She walked from the door in front of the room to the podium, and when she walked in, she was scanning the room. She walked by the area where claimant fell, by the outlet where claimant alleges that the laptop cord was plugged in. She didn't notice anything at that time. She testified that as a occupational therapist, one of the things occupational therapists do is they do environmental scans for hazards based on the type of patients that they typically see. Her history was with children, and she said that as part of something that she continues to do, she does these environmental scans, checking around for hazards. She testified that during the break, when she was putting up the stickies around the perimeter of the classroom, she was also checking the pathways where the students were going to travel as she was putting up the stickies. And specifically, she walked right because the activities were along the wall where because claimant was walking from one station to the next. She checked those areas as she was walking by and checked the area where claimant fell. Didn't see the laptop cord. Now I will say this: it is the state's position. We did dispute at trial. We still dispute whether or not there was in fact a laptop cord. And that it caused claimant's fall. However, we acknowledge that the commissioner did find that there was evidence of the laptop cord. However, there was insufficient evidence as it relates to this issue of constructive notice regarding the existence of the laptop cord. I'm sorry. I'm sorry, I did want to, yes, so like I said, there were 37 students had passed by there at the time of the fall, and, Professor Lancaster, like I said, she testified when she walked in, she didn't see anything in the area. Then she testified that during the break, when she was putting up the stickies, she didn't see anything. She also testified that during the activity, she was not only looking at the time, but she was also watching the students, seeing if they were having any difficulties. And she said as she was checking the room, she did not notice any students tripping or have any issues in the area where the claimant fell. Nobody reported tripping in that area or reported any issues with the laptop cord being on the floor. So we have 36 other students who walked by that area without incident. So the commissioner found Professor Lancaster's testimony regarding her environmental scans of the area credible and determined she did not have actual notice based on her scan walking in the room where she did not see a laptop cord, and while she was placing the stickies along the wall and did the environmental scan for hazards of the area, did not see the laptop cord. Also during the activity, she did not see the laptop cord, and like I said, no one mentioned having an issue. Based on a trial, claimant only testified that she saw the laptop cord after she fell, and it's several minutes after she fell. Commissioner Hamilton found her testimony credible that she did in fact trip on a laptop cord. Like I said, the state, did dispute that. We cannot, dispute Commissioner Hamilton's finding, but there is no evidence. Claimant did not present any testimony from anybody else present in the room other than Professor Lancaster regarding the existence of the laptop cord before claimant fell. So she doesn't know who owned the laptop cord. No one ever claimed ownership. Nobody knows what happened to the laptop cord. Nobody knows who put it there. Claimant's testimony, even at trial, was equivocal as to whether the laptop cord was plugged into the outlet or not, as she identified two different photographs. One that said it accurately depicted the location of the laptop cord and it was not plugged into the outlet, and then another one that was plugged in the outlet that she also said accurately depicted the appearance of the laptop cord. So Commissioner Hamilton found that it may have been plugged in, it may not have been.
There was no testimony that it was plugged in, was there? She didn't testify that it was plugged in. She didn't know, did she?
She didn't testify that it was plugged in, but the only evidence we have to go from based on what was introduced at trial is the photographs that she said, this one accurately depicts it and it was plugged into an outlet, and then another one accurately depicts it, the appearance of the laptop cord, and it was not plugged into an outlet. So Commissioner Hamilton correctly noted that it may or may not have been, the evidence was equivocal. So no inferences can be drawn from that equivocal evidence.
Well, when she fell, when the professor came and saw her, as I understand her testimony, not the professor's, but the plaintiff's testimony, the laptop cord was on the floor. And the commissioner stated she never, and she stated, I believe her testimony was she never saw a cord.
That is correct. Well, who said she never saw a cord? I'm sorry.
She never. She said she never saw it.
Claimant?
The claimant.
Claimant said she never saw the cord before she fell.
And then when she fell, it was allegedly on the floor.
It was allegedly on the floor, and I believe the deposition testimony that was introduced, the state introduced, it shows that she testified that she didn't see the cord until she was getting into a wheelchair.
There was no testimony that she saw it plugged in. If she never saw it.
Right. Okay, yeah, so she, I actually look back and there, she did not explicitly testify that she saw it plugged in. So to the extent that claimant argues that an inference can be drawn from the fact that it was plugged in at some point, but we don't know whom, you can't even draw, even that inference would be speculative, but you certainly can't draw any inferences from that statement because that was not unequivocally introduced at trial.
Well, the commissioner made a finding, however, she never saw a cord. He said that in his opinion.
He said she never saw a cord, but at the same time, he also said, she also testified that there was a cord. Yeah, that is a bit confusing, I understand, but I think that,
That's two different things, isn't it? I mean, she's testified she never saw a cord, but then after she's on the ground or whatever, she says she sees a cord, the commissioner goes along with that.
well,
But then we get into the constructive notice issue of how long it was there, no proof of that.
and I would agree. The state would submit that there was not sufficient evidence that there actually was a cord. However, the commissioner, even though he made those two statements, the way you read his ruling is that he found that there was a cord, however, there was not, notice to the state. The state did not, and that's our, while we submit that there is sufficient evidence that you could certainly find that there wasn't a cord, if you do find that, if you find the preponderance of the evidence does support that there was a cord, there still is no evidence of constructive notice. And I'm sorry, I've gotten off track. And again, Kleina's testimony was she didn't see the cord before she fell. It was several minutes after she fell. She doesn't know how the cord got there. She doesn't know when the laptop cord got there. She doesn't know what happened to it after her fall. She doesn't know who owned it. Professor Lancaster never even saw a cord. She responded, went to give her aid, never testified. She doesn't even have personal knowledge that the cord existed. She never saw it. And the quote-unquote evidence that Kleina relied on in her brief comes from a statement in Professor Lancaster's accident report that was excluded as inadmissible hearsay because it was based on what Professor Lancaster was told, and that isn't raised on appeal. To the extent that Kleina also relies that it was the method of operation or the nature of the activity that Professor Lancaster had the students engage in, that theory of proof for proving constructive notice has been rejected by the Tennessee Supreme Court in Blair versus Westtown Mall. Instead, in that opinion, the Tennessee Supreme Court adopted the pattern of conduct theory, which means if basically a dangerous condition results based on the frequency of occurrence, a pattern of conduct, then the defendant can be found to have constructive notice of the condition. However, the evidence in this case shows Professor Lancaster performed this activity 3 prior times without incident. She had performed numerous classroom activities and never had a claimant injured. She'd never heard of you never heard of anyone tripping over a laptop cord. University of Tennessee did not have any notice of prior incidents involving laptop cords. I believe my time is up, unless there are further questions.
I see none. Thank you.
Great, thank you.
I believe you have 5 minutes, Mr. Clark.
Thank you, Your Honors. Chancellor Golden, you were asking what Ms. Bryant testified to at trial, and at page 125, line 21 through 126, line 15 is where she testifies that. And she testified she didn't see anything when she fell, that she saw a cord on the floor when she got up, and she identified a photograph of the corner of where the fall occurred, which, and it's Exhibit 5, where there's a round table with a outlet plugged in right underneath it, and the cord laying there. All right, so that's the proof that's in the record from Ms. Bryant. And the significance of this is if you're having and I apologize if I said something wrong, I meant to say there were 38 people or 37 people going back and forth, is you're having these people go around the perimeter of this room, and she never says she checks the outlets. Now, UT Health Science Center didn't have any policies on trip and falls at the time. There were policies that came in after that made them have to do that, but the court excluded those. So that was the focus of the case. And what Ms. Lancaster, Professor Lancaster said, there were 2 times where she actually looked at the area. Okay, and on page 57 of the trial transcript, she was asked, before you started this activity, before you started that class, did you check the classroom for any hazards? Her answer was yes. Question, tell the court exactly what you did. Upon entering the classroom through the door in the photo, I scanned the classroom. Question, did you look at all the outlets to see if a plug was plugged in? No. And then she goes on, after you did your lecture, then did you give them a break?
Was there any proof or testimony from anyone that there was a plug that was plugged in? I'm not sure I understand how that photograph even got into evidence.
Well,
There was no testimony that there was a plug plugged in.
there wasn't, and whether it's plugged in or not is irrelevant in my thing. What we were trying to say is we had to look at all the hazards around the outside of the room. This cord ended up being in the same place as where a plug was and a table is, whether it was plugged in or not.
Well, there's no testimony, but I mean, I know we keep talking about not looking where the plugs were plugged in, that seeing any plugs plugged in, but there's no testimony that the plug was even plugged in.
Well, there is testimony that the cord was right by an outlet, by a table, to the left-hand side of the podium, not in the pathways of where Professor Lancaster asked people to clean up.
How'd you get there?
We don't know.
How long had it been there?
We don't know. As long enough, it's our position that it was long enough that she had the opportunity to, and did look twice, and didn't find it. If there are no other questions, I don't like to take all my time just because I have to.
Nice to see you.
I see you.
All right. Thank you. Thank you, counsel. We appreciate your argument. We appreciate your briefs.